Morning, Jess.
Morning.
Not going on, I'm fixing it.
Not what? So
That's just the dummy day, yeah.
on the 18th. Yeah.
Okay.
So it looks like you got 3 prisoners. Matthews, Marks, and Paul.
Matthews, March.
You said what?
Matthews, March.
Oh, I know. Matthews.
March.
Cole is a weed. The first one.
That's what it looks like.
Oh, are they here?
Yeah, she said, he's, the defendants will be walking through. Okay.
Wait. Calling case number 2355673, the people of the state of Michigan versus DeJuan Watt. Defendant is charged with count 1, reckless driving causing serious impairment of a body function. Count 2, failure to stop at a scene of an accident resulting in serious impairment or death. Count 3, false report of a felony. Count 4, moving violation causing serious impairment of a body function. This matter is scheduled for examination.
Good morning, Your Honor. Remind me on behalf of the people, P 82800.
And good morning, Judge David Cripps, P 34972, appearing on behalf of Mr. Watt, who's joined us by Zoom. Mr. Watt wishes to waive his exam today.
I'm sorry, can you say it again, Your Honor?
Can you state your name for the record, please?
DeJuan Watt.
Thank you.
Madam Clerk.
All right, Mr. Watts, you understand that you have a statutory right to a preliminary exam where the state must show by probable cause a crime was committed and probable cause you had something to do with committing that crime. You understand that, sir?
Yes, Your Honor.
Anybody promise you anything or threaten you in any way to get you to waive your right to preliminary exam?
No.
You waive your right freely and voluntarily after having opportunity to talk to your attorney about it.
Yes.
Do you have any objection to the court signing your name to the waiver form?
No.
Mr. Chris, do you have any objection to the court signing your name to the waiver form?
No, Your Honor, I don't.
All right, the court will find that you freely and voluntarily waive your right to preliminary exam as bound over Wayne County Circuit Court Criminal Division for arraignment on the information, which will be May 22nd at 9:00 a.m.
Thank you, Judge.
Thank you.
Bob. All right, take care.
All right, you too.
Thank you, Your Honor. You can sign off, Mr. Watt.
Okay, thank you, Mr. Cripps.
You're welcome, sir.
Oh, I'm sorry, I assume the people have no objection.
No objection.
No objection.
DEJUA.
Good morning, Judge.
You don't have to. Yes, it is.
It's the 12 o'clock exam. I'm sorry. Thank you.
Are we able to do Mr. Beasley now?
There's co-counsel, we need Mr. Brown, Mr. Cripps.
I'm gonna have to sign off for a while, then I have to start some, a lengthy sentence in here.
Okay. Mark Brown. Calling case number 2356101, the people of the state of Michigan versus Lavelle Smith. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for
Good morning, Judge. Alex Ronald, people, P number P86590.
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151, appearing by Zoom with Mr. Lavelle Smith, who's also present by Zoom. Mr. Smith, can you state your name, please?
Did you get any of that? Did you get
Not
any
the
of that?
first, I think he said 3 names. No, I wasn't
Mr.
clear.
Smith, can you state your name again? We can't hear you.
Lavelle Cordell Smith.
All right, thank you. All right, Mr. Cohen.
We have discovery, Your Honor. We're just asking for an exam date, please.
May 15th at 9:15.
Yes, thank you. That works.
All right, anything else?
Nope. Thank you very much, Your Honor.
All right, let's continue. Thank
Have a good day, everyone.
you. You too.
calling case number 2356632. The people of the state of Michigan versus Alante Gardner. Defendant is charged with count 1, weapons carrying concealed. Count 2, police officer assaulting, resisting, obstructing. Count 3, weapons felony firearm. This matter is scheduled for a probable cause conference.
Good morning, Judge. Alex Ronald, on behalf of the people, P number P86590.
Good morning, Your Honor, and the court. Veronica Walrad with NDS P85665 on behalf of Mr. Alante Gardner, who's present via Zoom. Mr. Gardner, if you could unmute and state your name for the record.
So Alante Gardner, Alante Christopher Gardner.
All right, Mr. Gardner, so you know when you come in here for your exam, I'll do t-shirts in my courtroom, even on Zoom. Please wear a shirt with a collar, all right? You don't have to worry about it right now. But when we come back, all right?
Okay.
All right, thank you. All right, counsel.
Your Honor, we are asking for an exam date to be set in this case.
May 15th at 9:30.
I have 2 sentencings at 9 a.m. at Frank Murphy, Your Honor, so that time might not work.
About 11 o'clock.
That would work, Your Honor. And I wanted to ask the prosecutor if discovery has been sent in this case. I have not yet received it. I know that I would have to submit a written order, but I just wanted to ask if it has been sent.
So discovery was sent, but it was sent to the generic neighborhood email, but I have your, now that I know you're the attorney, I can send it directly to you as soon as the PCC is done.
I would appreciate that. Thank you.
No problem.
All right, anything else?
No, Your Honor.
All right, close the hearing, bond continue. Thank you.
Calling, calling case number 2356650, the people of the state of Michigan versus Terrence Davis. Defendant is charged with count 1, weapons carrying concealed, count 2, police officer assaulting, resisting, obstructing. This matter is scheduled for a probable cause conference.
Good morning, Judge Alex Raymond, on behalf of the people, P number P 86590.
Good morning, Veronica Walrad with NDS P 85665 on behalf of Mr. Terrence Davis. I don't believe that he's present in the Zoom, but he has been letting me know he's having tech issues, so I would ask to waive his presence for this PCC.
All right, waive his appearance for the purpose of this hearing.
We are again just requesting an exam date in this case.
May 15th, 11:15.
That would work, Your Honor. Thank you.
All right, anything else?
No, Your Honor. Thank you.
All right, let's continue.
I have Mr. Kenny next, but I don't see him on.
Yeah.
He's still on.
You see him, Judge?
Yeah.
Okay. Calling case. Calling case number 2356671, the people of the state of Michigan versus Jermaine Childry. Defendant is charged with count 1, larceny in a building, count 2, assault or assault and battery. This matter is scheduled for a probable cause conference.
Good morning, Judge Alex Raymond, on behalf of the people, P number P 86590.
Good morning, Judge Robert Kennedy.
Kenny, you kind of faded out.
Hello?
Okay, yeah, can you put your appearance on again, Mr. Kenny?
Robert Kennedy appearing on behalf of Ms. Childress. 35842. Ms. Childress. Hello?
Yeah, go ahead.
Ms. Childress, I found out is in Lower Huron on a parole violation.
Oh, okay. All right, we'll waive her appearance for the purpose of today's hearing. Send this matter for exam. Mr. Kenny? Mr. Kenny? Mr. Kenny? Mr. Kenny? Mr. Kenny? Mr. Kenny, can you hear me? No, it's, it must have signed off. Robert signed right back on. Right. We have to,
Recall it.
yeah, recall.
Calling case number 2355952, the people of the state of Michigan versus Tasha Robinson. Defendant is charged with count 1, robbery unarmed. Count 2, assault with intent to do great bodily harm, less than murder or by strangulation. This matter is scheduled for a probable cause conference.
Good morning, Judge. Alex Ronald, on behalf of the people, P number P86590.
Good morning. Joseph Phelps, on behalf of Ms. Robinson, who is on. Ms. Robinson, please state your name.
Tasia Robinson.
I didn't hear him.
Okay. Send this matter for exam, Ms. Nelly.
Ms. Robinson,
Yes.
Did you?
No.
Judge.
yes, Your Honor.
And Ms. Allen, can you put your appearance on again? It didn't come through.
Joseph Alex, appearing on behalf of Ms. Robinson, P. 42284.
2284.
Thank you, Judge.
Did that
I
come
got
through,
it,
Judge?
yeah. Okay, we're setting the matter for exam.
Yes, Your Honor.
All right, May 15th at 9:30.
Judge, can we have it a little later? I have an in-person sentencing in Frank Murphy at 9 o'clock. Later in the day sometime?
10 o'clock.
That should
10 o'clock,
work.
10. That should work.
Fine, thank you.
All right, it's an in-person exam on May
It'll work.
15th at 10 o'clock.
Thank you, Your Honor.
All right, thank you. Bonds continue.
Calling case number 2356657, the people of the state of Michigan versus Ronald Anderson. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, weapons felony firearm. This matter is scheduled for a probable cause conference.
Good morning, Judge. Alex Ronald, on behalf of the people, P number P86590.
And good morning, Judge Arnie Chambers on behalf of Mr. Anderson, P63956. Mr. Anderson is here on Zoom. Mr. Anderson, could you state your name for the record?
Ronald Anderson.
All right, thank you, sir.
Judge, we have discovery. I'm sorry, Judge. Yeah, we have discovery. Just asking for a preliminary examination date.
All right. On May 15th at 9:30.
Yep, good. Thank you, Judge.
All right, thank you.
Have a good one.
All right, bonds continue.
Thank you.
Thank you, Your Honor.
Calling case number 235661, the people of the state of Michigan versus Antonio Sanders. Defendant is charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons, ammunition, possession by a felon. Count 3, weapons, felony, firearm. Count 4, weapons, felony, firearm. Habitual offender for notice. This matter is scheduled for a probable cause conference.
Good morning, Judge. Alex Swearing on behalf of the people, P number P86590.
Good morning, Attorney Sidney Henderson on behalf of Mr. Sanders, P84839. Mr. Sanders, can you please state your name for the record?
Antonio Sanders.
All right, Mr. Sanders, I believe you were on, and you heard what I said about T-shirts in my courtroom?
No, sir, I'm sorry.
All right, well, don't worry about it right now, but when you come in, make sure you have a shirt with a collar on, please.
Yes, sir.
All right, thank you.
Thank you.
All right, Ms. Henderson,
Yes, Your Honor, we would ask if the prosecutor had an offer. We haven't heard anything just yet, but we will first check to see if they have an offer in the case.
No, there's no offer.
no, there's no offer right now.
Then we'd be requesting an exam date, Your Honor.
All right. May 15th at 9:45.
That works.
All right, the in-person exam at 9:45 on May 15th.
Thank you, Your Honor.
All right, thank you. Let's continue.
Calling case number 235659, the people of the state of Michigan versus Shaquan Cole. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for a probable cause conference.
Good morning, Judge. Alex Swearing on behalf of the people, P number P86590.
Good morning, Your Honor. Chad Kadaf, P82492, appearing on behalf of Shantwani Cole.
Ms. Cole, can you state your name for the record, please?
Shantwani Cole.
Thank you.
Your Honor, respectfully request an exam for this matter. We are in full receipt of all the discovery that the people have already sent over.
May 15th at 10:30.
That works for the defense, Your Honor.
All right, anything else?
No, thank you, Your Honor. Have a great day to you and your staff.
You too, take care, bonds continue.
Thank you.
Welcome.
Calling case number 235659, the people of the state of Michigan versus Emil Cole. Defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. Count 2, weapons carrying concealed. Count 3, motor vehicle code, intent to pass false title. Count 4, weapons firearms, possession by felon, count 5, weapons felony firearm, count 6, weapons felony firearm, habitual offender, second notice. This matter is scheduled for examination.
Good morning, Judge. Alex Miranda, on behalf of the people, P number P86590.
And good morning, may it please the honorable court, Sophia Curry, P72103, appearing on behalf of Emil Cole, who is present in the court. Mr. Cole, please state your name for the record.
Emil Cole.
And Your Honor, this is going to be a waiver of an examination. I did have a conversation with Mr. Cole regarding his right to an examination, the limited purpose of an examination. We also discussed the fact that this matter would automatically be bound over to the Third Circuit Court, and that he could not come back at a later date and ask for a preliminary examination. Is that correct? We had that discussion?
Yes, ma'am.
And you wish to waive your examination too?
Yes.
Thank you. People have any objection?
No objection.
All right, Mr. Cole, you understand that you have a statutory right to preliminary exam where the state must show by probable cause a crime was committed, and by probable cause you had something to do with committing that crime. You understand that?
Yes, sir.
Anybody promise you anything or threaten you in any way that you waive your right to preliminary exam?
No, sir.
You waive your right freely and voluntarily after having an opportunity to talk to your attorney about it.
Yes, sir.
You signed the waiver of examination form?
Yes.
All right, court will find that you freely and voluntarily waive your right to preliminary exam. Matter is bound over Wayne County Circuit Court Criminal Division for arraignment on the information, which is May 22nd, 2023 at 9:00 p.m. And bonds continue.
Thank you, Judge.
Okay.
Your reference correct.
RUFF. All right, thank you, Mr. Brown. Yes, he is, yeah. All right, okay. Okay.
Mr. Cripps,
Hi, Kitty.
Mr. Brown said he's gonna be logging on.
Okay.
All right, so, and Mr. Kenny didn't come back, did he? No?
Yeah.
This is a different, no, that's the, oh, that's right.
All right, Mr. Brown.
Yeah, no, I was just calling you to tell you I got off Zoom because I got called and the BCC.
Mr. Brown,
Thank you very much. Yes, ma'am. Sorry about that.
are you ready?
I didn't hear him. Did he say here? Oh. Oh,
Yes,
he's on
ma'am.
mute.
Sorry.
Yeah, okay, all right.
All right, Mr. Cripps, are you still driving?
Oh,
Yes, I am, Your Honor.
Okay, can you pull over so we can do this?
I'm on the freeway. I'm on my way to another courthouse. I'll try to do the best I can here and pull over.
Well, I'm gonna have to wait till you pull over. I can't do it while you're driving.
is he put over?
Yeah.
Like he stopped.
Your Honor.
Okay, you ready?
Yes.
Calling case number 2356668, the people of the state of Michigan versus Anthony Ruff. Defendant number 1 is charged with count 1, motor vehicles operating the chop shop. Count 2, breaking and entering a building with intent. The people of the state of Michigan versus Timothy Beasley Jr. Defendant number 2 is charged with count 1, motor vehicles operating the chop shop. Count 2, breaking and entering a building with intent. Controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. These matters scheduled for probable cause conference.
Good morning, Judge Alex Rangus, and for Attorney Blackburn, P number P86590.
Good morning, Your Honor. Excuse me. Good morning, Your Honor. May it please the court. My name is Mark Brown. My P number is 562 here on behalf of Mr. Anthony Ruff. who, Mr. Ruff is not present on Zoom. I don't have an explanation for his failure to appear. I'd like to set this for, I know I'm getting ahead of myself, but I'm just saying this because I would love the opportunity to go over the discovery with him and meet with him.
Hey, good morning, Judge.
Hold on, Mr. Cripps. Mr. Brown, you just totally faded out. Okay, are you waiving your client's appearance?
Yes, Your Honor.
Okay, all right, and you said you wanted to set it for exam, because I couldn't hear the rest of it.
I'd like to set it for exam. I think it's already scheduled for the 15th, which is not a good day because I have a couple motion hearings in Macomb County on that morning already scheduled.
All right, Mr. Cripps.
Good morning, Judge. David Cripps, P34972, appearing on behalf of Timothy Beasley, who's joined us by Zoom.
Defendant Timothy Beasley.
Thank you, sir. All right. Mr. Brown, could you do like late morning, like 11:30 on the 15th?
Judge, I hate to interrupt, but I'm going to probably be finishing up a homicide trial that day on the 15th, starting tomorrow.
All right.
Your Honor, could I suggest the 17th? Is that a good day? Is that a good day for you and or Mr. Cripps?
Is there any afternoon times available that day?
Latest I can do is about 11:30.
The 17th?
Yes. Can you do that, Mr. Cripps?
Yes.
I can do that if Mark can do it.
Yes, that's fine. 17, 11:30.
All right, we'll come back on May 17th at 11:30.
Thank you very much, Your
Judge.
Honor.
Thank you, Judge.
All right, thank you.
Thank you, Madam Clerk.
You can sign off, Mr. Beasley.
Thank you.
Thank you, Kitty.
You're welcome. Yes. Calling case number 23-56671. The people of the state of Michigan versus Jermaine Childry. Defendant is charged with count 1, larceny in a building. Count 2, assault and battery. This matter is scheduled for a probable cause conference.
Good morning, Judge. Alex Wayne on behalf of the people, P number P86590.
Good morning, Judge. Robert Kenny, appearing on behalf of Ms. Childry, 35842. Ms. Childry is in Northern Huron with its facility on a parole violation. That's why she's not here today.
Okay. All right, we'll waive her appearance for purpose of today's hearing.
Thank you, Judge. I'm gonna ask you to consider giving me another probable cause conference. Let me get to know Ms. Childry.
All right, I'll adjourn the probable cause conference. I'm just gonna set it for exam. I gotta set it out far enough that we could rid her out.
Okay.
Opportunity to talk to her.
That'd be fine.
Yes, sir.
And you, 22nd, 23rd, you need at least 10 days to rest up.
Yes.
23rd, I guess. See what we got.
So the 22nd, 24th, 23rd. Federal courts, most of that day.
25th,
25th and morning.
yeah,
Yep.
that's good.
We don't have anything.
9 o'clock?
Okay. Yes, exam, right?
Yes.
Thank you, Judge.
May 25th, May 23rd, 9 o'clock for exam.
Thank you, Judge.
Thank you.
Yes, that's what it said.
Yeah. I'll send them the Zoom. Okay. Okay.
Mr. Kenny,
Yes, sir.
you said 9:30, so if they're coming from the jail, they might not be here.
That's right.
9:30?
Yes, sir.
You change it.
Parties ready in Hopkins. Calling case number 1957084, the people of the state of Michigan versus Brian Hopkins. Defendant is charged with count 1 and count 2, identity theft. This matter is scheduled for examination.
Good morning, Judge. Alex Ring on behalf of the people, P number P86590.
Good morning, Your Honor. Veronica Walrod with NDS PH5665 on behalf of Mr. Hopkins, who is present behind me in the courtroom. Mr. Hopkins, if you can state your name for the record.
Brian Jamar Hopkins.
Thank you. Are you ready?
The people are unready to proceed as the necessary witnesses failed to appear.
And the defense would move to dismiss, Your Honor.
Now let's dismiss without prejudice.
Okay, there you go. Okay.
Trying to get the same thing.
We don't have to. Thank you.
Rima, you not doing the last one?
I don't know how they wanna do it.
I think we're gonna do his first.
Okay.
He wanted to do yours, because you were here and the other prosecutor wasn't here, so he was like, I don't wanna just sit here and wait. But since he's here, he'll do him first.
Okay.
Okay.
We think, we
Huh?
think.
Oh, we think?
We think, we don't know yet.
Why?
They're having sidecar.
Oh, great. I just wanna know which one am I calling first?
They went in one way, they might come out another way. Once it goes through that door. One thing for sure.
I just wanna know which one to call first. That's it.
One thing for sure, you're gonna call one of the other.
But which one?
Call four cases first. One part of it. State. State, and then we're gonna do other cases of continuation. Individuals.
Oh, okay, so I'm gonna call them all at one time. Okay.
You won't have to recall them, but just, I can promise that.
Alright. Are we ready?
Yeah.
Absolutely. Totally different.
Oh. Parties ready on Demario Mathis, calling case number 2356347, the people of the state of Michigan versus Demario Mathis. Defendant is charged with count 1, robbery armed, count 2, weapons, firearms, possession by a felon, count 3, weapons, dangerous weapon, carrying with unlawful intent, count 4, count 5, count 6, weapons, felony, firearm. Also calling case number 2356001, the people of the state of Michigan versus Demario Mathis. Defendant is charged with count 1, robbery armed, habitual offender for notice. Also calling case number 2356346, the people of the state of Michigan versus Demario Mathis. Defendant is charged with count 1, weapons carrying concealed, count 2, weapons, firearms, possession by a felon, count 3, weapons, felony, firearm, habitual offender for notice. Also calling case number 2356000, the people of the state of Michigan versus Demario Mathis. Defendant is charged with count 1, stolen property, receiving and concealing motor vehicle, count 2, police officer fleeing, third-degree vehicle code, habitual offender for notice. These matters are scheduled for examination.
Good morning, Your Honor. Brendan Sawyer for the people, P83033.
Good morning, Your Honor. Remind me on behalf of the people, P82800.
May it please the court, Neighborhood Defender Service of Detroit by Jeffrey Konecki, P64800, on behalf of Mr. Mathis and all matters. Mr. Mathis, please state your name for the record.
Yes, sir. Demario Mathis, Your Honor.
All right, ready to proceed?
Yes, Your Honor. This time, we're going to call our first witness, which is going to be Sergeant Kevin Kainis.
All right, and just so that the record is complete, we had a off the record discussion regarding how we would proceed in this matter. This first witness has to do with a statement taken. Notice that in that statement, it goes to all 4 cases. Is that correct?
It goes to 3 of the 4, correct, Your Honor.
Okay, 3 of the 4 cases. And so we're going to take the statement as to, and then we'll go to 3 cases, and then we'll do a continuation as to each case. Yeah.
Yes, sir, I would agree with that. Yes, Your Honor, that's good.
All right.
Don't do it.
Kevin,
Hannes, Hanus.
You swear our affirm, tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right? Your name again, please?
Kevin Hannes,
I didn't get the last name, sorry.
Hannes,
Hannes, Hannis,
Hanus.
Hanus.
Your Honor, my officer in charge, Detective Hunt, has come in. I would just ask for a mutual sequestration with an exception for my officer in charge.
No objection.
All right, any witnesses testifying today at trial or anytime in the future must leave the courtroom or be denied their future testimony. That includes YouTube and Zoom, with exception to the officer in charge.
Thank you, Your Honor.
Thank you.
Sir, if you please introduce yourself to the court.
Sergeant Kevin Hannes,
And Sergeant Hannis, how are you employed?
City of Detroit Police Department,
How long have you been employed with the City of Detroit Police Department?
26 years.
All right. And during those 26 years, have you had many opportunities to perform interrogations of suspects?
Yes.
And any idea how many you've done?
That's irrelevant.
I'll move on, Your Honor. Officer, are you aware of the policies and procedures with performing interrogations?
Yes.
And you're experienced in them?
Yes.
All right. Can you just walk us through what you do to perform an interrogation?
What's the relevance?
He's the officer who performed it and then he did
Well,
it.
if he's gonna walk us through what he did in this case, it's relevant. If he's gonna walk us through what he normally does, I don't care.
I'll move on, Your Honor.
Okay.
Sergeant Hannis, at some point, did you perform an interrogation of an individual named Demario Mathis?
I did.
And do you recall when you did that?
The exact date and time I don't recall.
And when you did so, did you go about advising him of what are sometimes referred to as Miranda rights?
Yes, I informed him of his constitutional rights.
And did you in fact do that in this case?
I did.
And did you ultimately document that in some way?
Yes.
And how did you do that?
On a constitutional rights form.
And is that something provided to you by the Detroit Police Department?
Yes.
And would Mr. Mathis have read it?
Yes.
Would he have signed it?
Yes.
And did he do so in this case?
Yes, he did.
Okay, 1 second. Mr. Konecki, are you willing to, for purposes of preliminary exam only, stipulate that your client received, understood, voluntarily waived his constitutional rights, Miranda rights, and made a statement?
No, Your Honor, I would like the opportunity to voir dire on the voluntariness.
Okay, then you can complete first. You can finish then.
All right.
Go through that. I was trying to see if we could shortcut it.
Fair enough. Sergeant Hannis, you said you documented that on a constitutional rights form?
I did.
Permission to approach the witness, Your Honor?
Yes.
And Sergeant Hannis, I'm handing you here what's been marked on the front as people's proposed exhibits 1 and 2. I just want you to take a look at those and then look back up. Sergeant Hannis, you recognize those?
I do.
What do you recognize them as?
This is the constitutional rights form I used prior to the interrogation of Mario Mathis.
And what was the date and time on that?
That was March 16th at 11:25 a.m.
And is there anything on this form that Mr. Mathis himself would have written?
Yes.
And what are those things? What are those parts?
How I conducted this advice of rights is my first act was to ascertain whether or not Mr. Mathis can read. So I have Mr. Mathis read statement 1 aloud, okay? Then I asked him if he understood statement 1. And I said, if you do understand statement 1, please put your initials by statement 1. I then continue to read while he reads aloud. And I would read, and in this case, I read statement 2. And I asked him if he understood statement 2. And I said, if you do, put your initials by statement 2. I then moved on to 3, 4, and 5, like the same protocol.
And in this case, Mr. Mathis indicated that he did understand each of them?
Yes.
And he was able to read in English out loud those portions that you asked him to?
Yes.
At any time, did he appear intoxicated or under the influence of anything?
No.
And at the time, did he ask for any sort of medical attention or anything like that?
No.
Then I'd ask that the court find Mr. Mathis' statement is voluntary knowing, or Mr. Kennedy for some what here.
Thank you.
Right here.
Officer Hannis?
Sergeant.
Sergeant, I apologize. Missed that. Sergeant Hannis, how long was Mr. Mathis in custody before you talked to him?
I don't recall, I believe it was the night before he was arrested, probably in the early afternoon, late afternoon, somewhere around there.
Okay, and then this, when you're interrogating him, is somewhere in the area of about 11:25 a.m.?
Correct.
Okay, so he had been in the lockup all night. Where was he at? Was he at a district or DDC?
The DDC.
DDC, okay. Now, from when he was arrested and brought into the DDC, is it fair to say you didn't have any contact with him until you met with the statement, correct? You met to talk with him about the statement, is that fair?
That's correct.
Okay. So you don't know if he was denied any sleep or denied food, fair to say?
I don't know what his contact was.
Fair. When you were taking the statement with him, who else, was anyone else in the room besides yourself and Mr. Matthews?
Yes.
Okay. How many people?
Lieutenant Down.
Were you and the lieutenant both armed while taking the statement?
No.
Was Mr. Mathis cuffed while he was in that room?
No.
Now, did you talk to Mr. Mathis before you started going over the constitutional rights form?
I believe he talked about the weather on the walkover.
Okay. No, anything in the interrogation room? Any conversation between you or the lieutenant with Mr. Mathis prior to the start of the constitutional rights form?
No, I don't believe so.
Thanks, Will. Nothing further.
I renew my motion, Your Honor.
Object to the record. Your Honor.
I got a few questions. Did the defendant ask for water or food at any point?
No.
Did he appear lucid in that he answered the questions that were asked of him?
Yes.
And did he appear to be under the influence of any type of drug or alcohol?
No, he did not.
All right, any questions based on my questions?
No, Your Honor. Did you ask him if he was under the influence of any sort of intoxicant, alcohol, medication, prescription pills, anything along those lines?
I don't recall if I did so.
Anything else?
No.
All right, then the court's gonna make a finding that the defendant did in fact receive, understood, and voluntarily waived his Miranda rights and made a statement. So it goes straight into the statement.
Thank you. And Sergeant Haynes, after you take a statement from someone, do you summarize it in written form as well?
Yes, typically what I do is I just engage in conversation, right? And in this case, I'm sorry, in this case I did. I just talked. We just talked, went over cases, and then at the end, I condense it to writing.
And is that what you have in your hands there as People's Proposed Exhibit 2?
Yes.
Is that dated and timed that same date of March 16th, 2023?
Yes.
And is that your handwriting on it?
It is.
All right, and is that Mr. Mathis's signature on it?
Yes.
On the first page?
Yes.
And does that form, do either of these forms have appeared to have been altered or modified in any way?
No.
Your Honor, I move to admit People's Proposed Exhibits 1 and 2.
Your Honor, no objection on, exhibit 1 is the constitutional rights form. I have no objection with that one, Your Honor. My issue with exhibit 2 is that the sergeant had indicated that what he has here is a summary of the statement that my client gave. His recollection is he indicated they had a conversation, they were talking, and then it was reduced to writing later. I don't believe that that's the appropriate, what they should be entering is the conversation, the statement my client gave, not the sergeant's version of it, his attempts to consolidate it into what he believes is a concise statement. It should be the statement that my client gave, not his summary of it.
Ultimately, it is Mr. Mathis's statement. He testified that he observed, he provided it to Mr. Mathis to review for accuracy purposes and such. And in fact, Mr. Mathis signed it and adopted it as his own statement. But nothing.
Okay, so is the statement in question and answer format?
Yes, sir.
Okay, so are these the specific questions that were asked of him, and those are the specific answers that he gave?
Correct.
But you didn't, change him anyway, change his answer,
No, in fact, I read them as a rule and I asked him the questions and he answered.
okay, and when you presented the statement to him,
Yes,
he had an opportunity to read that statement.
he did.
Okay, and then he signed off on that statement.
He did.
All right, the court's gonna allow it.
And Sergeant Haynes, there also video and audio recording in the rooms that you do these interrogations in?
There is.
All right, and was this interrogation video and audio recorded?
Yes.
And did that video recording fairly and accurately capture your conversation with Mr. Mathis back on March 16th?
It did.
Your Honor, I move to admit.
If you admit it, I gotta listen to it. So why do I need it? If he's gonna give the statement and he's gonna read the statement into the record, what else do I need?
So there's one portion of the interrogation that is in the video that is not in the written statement. It relates to the receiving and concealing case. So as far as the armed robbery cases, the written one as admitted as Exhibit 2 is going to be more than sufficient. But it says for the receiving and concealing case, which this video was also provided in discovery, and that was all part of this larger investigation. So it'll ultimately be just a fraction of the overall video.
You're gonna renew my objection that, again, this has been reduced to writing and everything. We already have another instance where there's something on the interrogation video that's not reduced to writing. So it's not the full statement.
Well, first of all, there never is a full statement. There's always some conversation that is not included. Now, the officer, in this case, I'm assuming as in almost every other case, they put in what information they feel is relevant to the case in front of them and the charges that he feels are going to be submitted to the prosecutor's office. I'm going to go ahead and allow it. And we'll do the, we're only doing a portion of the video that's
correct,
relevant to the other case. All right.
Just ask if the court would enable share screen so I can play it up there. Sergeant Haynes, I'm going to have you turn towards that screen there and look at what's been just admitted as People's Exhibit 3. Do you recognize that room, sir?
Yes.
All right. What do you recognize that as?
It was in an interview room at the DDC.
And I'm going to go to 11:27 and 40 seconds a.m.
All right, so you know what we do, right?
Yes. You said, do I know what y'all do?
Mhm.
Yeah, yes, sir.
All right, you know why you're here today?
Yeah, I know I was riding in a stolen car. I know that, but.
So heard you're quite a driver, is what I understand. Heard you're quite a driver.
I was
saw the
just
video,
scared,
that was
man.
impressive, man.
Yeah, I was just scared.
You don't give yourself enough credit on that one.
Yeah.
Obviously not your first rodeo.
Yeah.
Where'd you get the car from?
I bought it off the street, for real.
Yeah.
$600, the keys to it. I know I shouldn't really
That's
ride around.
that's a pretty good price for a brand new Explorer.
Yeah, I knew it was stolen though.
Yeah.
I just needed something to drive, for real.
Yeah, where'd you get it from?
This one guy.
And just for the record, I'm stopping it at 11:28 and 25 seconds a.m. There's nothing further from this exhibit. And
Well, you're gonna go into the statement on that exhibit. You're gonna go into the statement.
yes, yeah, I'm going to circle back to Exhibit 2 now. And Sergeant Haynes, did you at some point ask Mr. Mathis regarding a series of armed robberies?
Yes.
And what was your overall role in this investigation?
This is my only part of this investigation. I really played in it. I started off with a detective, then went to another detective, and then the arrest happened and I conducted the interrogation.
And during the course of this interrogation, did you ask about a robbery at 7 Mile and Bentler Street?
I believe I did.
To refresh your memory, look at your.
Actually, we submitted the.
I'll publish it to the court.
You can either publish it or you can have them read it. Because normally you just go read the question and then the answer in that form of passion, and I take it from there. Okay.
All right, Sergeant Haynes, you testified you inquired about a robbery at 7 Mile and Bentler?
Yes, I can actually just read my statement into the record.
Yes, please do.
Question, do you understand the constitutional rights? Answer, yes. Question, tell me about the robbery attempt at Minnesota and Norfolk. What?
That a little slower.
I'll slow down. I apologize.
I'm sorry.
Yeah.
Your Honor, the first, I guess technically the second question in the statement has to do with a case that is not before the court. There's no charge. There's nothing with regard to that one. So I would object to that question and answer being entered in. There's no relevance to this case, either of the robberies, either of the other two cases.
I have a copy I'm prepared to publish to the court as well, if we'd like to sort of follow along.
Yes.
All right, permission to approach?
Yes, but I think you have the argument as to this objection.
Oh, I would agree, Your Honor, with defense counsel's.
All right, so court's gonna strike that part.
Sergeant Haynes, let's go to sort of the bottom of page 1. You start there. Tell me about the 7 Mile and Bentler attempted robbery.
Okay. Question, tell me about 7 Mile and Bentler attempted robbery. Answer. We rolled up, my friend was still driving. He rolled the window down and told the guy to give him everything. The guy took off running. Question, where were you seated and who was driving? Answer, I was in the front passenger and my friend was driving.
And then if you could continue with that next question as well.
Question, tell me about the robbery at 19185 Lenore on 6/3/23 at 2:48 p.m. Answer, I was driving and my friend was the passenger. We saw the woman at the back of the car. My friend jumped out, stuck his hand in his coat like he had a gun. She said, "Don't kill me." I told him where her purse was. My friend then went to the side door of the car and took the purse. I looked in the purse and there was nothing good in it, so I threw it out on the next block.
I'm sorry, stop for a second. Your Honor, again, this last question and answer regarding a robbery on Lenore Street is also not a case, not charges that are against my client. So I would again ask for question and answer that one to be stricken from the record.
And I would agree with defense counsel on that. Sergeant,
strike the testimony.
You could go to the next question though about Schaefer.
Okay. Question, tell me about the robbery at 20516 Schaefer at 3:13 p.m. Answer, I was driving the white Explorer and we pulled up on the older woman. She was walking to her car and we pulled up. My boy said to her, give him her stuff. She threw the lotto tickets in the air. She threw her purse in her car and we drove off. Question, where was the rifle during the robbery? Answer, in the back seat.
No further questions from the people for this witness, Your Honor.
How long was the interrogation process?
Let's see. Referring to the interrogation sheet. I began the interrogation at 11:25 a.m. and I concluded it at approximately 12:50 PM.
Okay, so about an hour, a little under an hour and a half.
Give or take.
And in that time, the statement that you reduced to writing from my client was approximately 2 full pages, 3 typed page, written pages, but spaced out the statement itself. Is that fair?
Correct.
Okay. And when he was in the room with you guys, was he offered food or use of the bathroom?
I did not make those offers.
And you indicated you did not ask if he was under the influence of the documents.
I don't recall if I did.
Thank you.
Nothing further from the people, Your Honor, for this witness.
Looking at the statement. The statement has a signature on the first page, but it does not have signatures on the second and third page. So this was not done in a, this is the question, this is the answer format. This was done in afterwards, in more of a summary. And it's put on the record earlier that Mr. Mathis adopted this statement as his, by putting his signature on, on the document. Only got the signature on the first page of the document. So as far as I know, he did not adopt the second or third page.
I can ask some further questions of the sergeant as it relates to that. So, Sergeant Haynes, you testified just now in response to defense counsel that was an hour and a half long interrogation roughly?
Yes.
All right. Are you writing out the whole time, or how does it all work?
I don't touch my pen for the first portion of the interrogation. I just talk. Just talk about this. I might look through some paperwork, get the right locations, date and time. So I don't put anything to writing at that time. Typically, I found, in this case, especially Mr. Mathis, he got very agitated when I started writing his statement down. I don't believe he understood that the whole conversation was recorded, but he got very agitated. And I went through and I read him the statement, word for word. And then I said, is there anything I have to change about it? Do you agree with this? Yeah, I'm just sign the first page, then I'm not signing it. But he had read the entire statement as I just read it.
And those were his answers in response to you reading it?
Right.
Do you, during the course of the interrogation, sometimes ask the same question over and over?
Yes.
And did you do that in this case?
I don't remember exactly how the entire conversation went.
And this entire interrogation was in fact videotaped and audio recorded?
Yes.
And the videotape and audio recording accurately captures the same things that you put in summary and gave to Mr. Mathis to review and adopt as well?
Yes.
No further questions, Your Honor.
Mr. Mathis signed the first page you indicated, correct?
Yes.
Refused to sign the rest?
Yes.
Did he initial each question and answer? Did he initial each question and answer in the statement?
No.
Thank you.
Thank you.
As people call Officer
Wait. Okay, that concludes, nothing else as to that.
I don't believe there's anything else as to the statement other than the court's hesitancy and my objection with regard to the adoption of the statement as he taught. The only signing the first page.
Okay, I need to know what your objection is.
Oh, I'm objecting to the as the evidence was presented, the statement was placed in the record. It was indicated that Mr. Mathis adopted the statement as his own. But as the court indicated, he signed the first page indicating he adopted that part. The rest of it was not signed, indicating that he did not sign, he did not adopt it. He also did not initial questions and answers throughout of it, which would have been another indication that he was adopting that as his own. That's not present. The only part of the statement that is adopted by signature from Mr. Mathis is the first page, which basically says he understands his constitutional rights and then there's an irrelevant question to the case before the court.
I have to say, there's no case law that I'm aware of that requires him to sign it. You know, in a sense, the written summary attributed to the defendant is a matter of weight in the same way that any other witness is saying a defendant or witness told me this or that. And so sort of beyond that, I don't know that the lack of signature itself precludes its admission at this stage.
I just, Judge, my issue is they indicated that this was a summary of the interview. And we have roughly 2 pages written of questions and answers for an hour and a half of an interview. And then they're indicating that this was a summary that he adopted when we showed him, but we don't have that. We have him signing page 1, refusing to sign the rest, which would be indication that I believe with what I agree with what you said here. I am not agreeing with the rest.
The court would take the position that the statement itself, the written statement, with the defendant's signature on the bottom of page 1 is, as stated, admission by an adoption by the defendant of that as part of the statement. Now, as to page 2 and page 3, that's not done. But, you know, the issue is this is a probable cause hearing. And because the officer testified that, you know, those were the exact questions that he asked, and those were the exact answers that the defendant gave. And in reality, I don't need a statement, a written statement. You know, I have the officer's testimony that this is what in fact was said, and it was a defendant's statement, and that as a result, that statement can be used, you know, against him. But just so the record is clear, as to the written statement, the court is not adopting page 2 and page 3 as further that the defendant adopted those pages as his statement. But I am taking the officer, you know, at his word that this is what was said, this is what was asked, and these are defendant's responses therein. So, and that's how I'm going to take it. All right.
Thank you, Your Honor.
Thank you. Before we go on to the next one, I got a quick dismissal. We do the Kevin Marks info.
Calling case number 23-56169, the people of the state of Michigan versus Kevin Marks. Defendant is charged with count 1, larceny in a building, count 2, assault or assault and battery, count 3, larceny less than $200, habitual offender for notice. This matter is scheduled for examination.
Good morning, Judge Alex Ring, on behalf of the people, P number P86590.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973, on behalf of Kevin Marks. Mr. Marks is present in the courtroom right next to me.
What's your name, sir?
Kevin Dwight Marks, second.
Thank you. All right, you ready to proceed?
The people are unable to proceed as the necessary witness has failed to appear.
And to move to dismiss.
All right, you guys dismiss without prejudice.
Thank you, Judge.
Thank you, Your Honor.
Just step back.
I'm just waiting, man.
I understand you.
Okay, we ready to proceed as to Mr.
Yes.
Mathis? Okay, which case are we doing? Because now these are a continuation as the individual cases.
This is the stolen property case, Your Honor.
What's it ending with?
It ends in 0001. 00001. I believe it's the first 1030.
Two cases that end 5600. Oh.
23056000001. 401.
40. All right, this is case number.
Mr. Matheson, question.
Oh. All right, this is case number 2356000. People of the state of Michigan versus Mario Mathis, charged in count 1, stolen property, receiving and concealing motor vehicle, and count 2, police officer pleading third-degree vehicle code.
Good morning, Your Honor. Remind me on behalf of people, PA2800.
Okay, Police Court Neighborhood Defender Service of Detroit by Jeffrey Konecki, P64800, on behalf of Mr. Matheson. Mr. Matheson, please state.
Sorry, the Mario Mathis, Your Honor. Thank you. All right, ready to proceed?
There's just a preliminary matter for the date of the offense. We're going to be changing that to March 15, 2023. And then the location will have to be St. Mary's and West McNichols in Detroit.
Date of offense is March 15th,
Yes,
2023. And the location,
St. Mary's and West McNichols.
make anything you wanna?
I'm sorry, Judge.
I assume you have no objection.
No, Your Honor.
You can call Officer Durant.
Officer
Durant.
Grant.
Bless you.
Thank you.
Officer Kyle Durant.
Step up here, please. Raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I did.
Close the door to me, and that's it, please. I want to bring the other microphone there, just bring it down just a little bit. A little bit. Thank you. May proceed.
Thank you, Judge. Good morning, officer. Please restate your full name for the record.
Good morning, Officer Kyle Durant,
And where are you currently employed?
City of Detroit Police Department, 8th Precinct,
And how long have you been employed by Detroit Police?
2.5 years.
Were you working on February 3rd of this year, 2023?
I was.
Okay, on that date, what were you assigned to do?
I was on general patrol in the 8th Precinct.
Okay, so I'm gonna turn your attention to February 3rd at around 4 p.m.
What date?
February 3rd, at 4 p.m. Were you called anywhere?
Yes, so I was dispatched to Greenfield and the Lodge Freeway
For what purpose?
for a UTA report.
For a what report?
UTA,
Okay, do you remember the name of the individual that made a report?
yeah, so Mr. Ronald Harris is the one that called. The vehicle ended up being an Avis rent-a-car. We took the report from Mr. Harris, filled out the UTA affidavit, ensured no one had permission to drive the vehicle.
Okay, what kind of vehicle was it?
It was a white 2021 Ford Explorer.
Okay, and at the time, did you write a VIN number down for the vehicle?
I did.
Your Honor, I believe the defense will stipulate to me reading the VIN into the record.
For exam purposes, that's correct, Your Honor.
The VIN number 1F Mary S K 7 F as in Frank H 2 Mary G A 88812. And officer, you indicated that did Harris, the person owner of the vehicle, indicate that they gave permission for anyone to take the vehicle?
He stated no one had permission to take the vehicle.
Okay, so now I'm gonna turn your attention to March 15th of 2023. Were you working on that day?
I was.
And what were you assigned to do?
General patrol, same as before.
Were you working alone or with a partner?
I was Scout 85 working with Officer Hotman.
Okay, were you driving a marked scout car on that day?
So I was jumping, so I was a passenger in the vehicle, but yes, the scout car was fully marked.
And were you and your partner in uniform?
We were fully
Okay.
uniformed.
And on that day, did you make the location on St. Mary's and West McNichols?
Correct.
Is that in Detroit, Wayne County?
It is.
Okay, and did anything happen on that day that brings us to court today?
So if you look, we had been looking for a white Ford Explorer with black rims, wanted in conjunction with some armed robberies. It had been chased about a week, maybe a couple days prior by a different DPD unit.
Okay, I can't, unless you're gonna give me a foundation, I can't take any of this.
Okay. So were, on that day, were you looking for a Ford Explorer or you happened to see a Ford Explorer there?
Yeah.
Both. So I had happened to be looking for one white with black rims, and we had spotted one at McNichols and St. Mary's.
Okay, and after you spotted a white Explorer with black rims on St. Mary's and West McNichols, what if anything did you do?
So we pulled behind it to try to initiate a traffic stop, just to ensure that it, is or is not the vehicle that's wanted. When my partner, Officer Hoffman, activated the overhead lights, the vehicle fled from us, activated
Okay,
siren.
When it fled from you, where did it flee from?
So we were 1 block north of McNichols. It was on Santa Maria, going westbound. So it was a residential neighborhood, 25 miles an hour.
Okay, and after it fled, did you continue to pursue the vehicle?
We did.
Okay, tell me how you continued to pursue the vehicle.
So the total pursuit was 14 minutes long. It primarily went in neighborhoods, but also went on Evergreen, McNichols again. Went on Southwood Freeway, going the opposite direction of traffic. Got off the freeway. Ultimately, the pursuit came to an end after the white Ford Explorer struck some big rocks cutting through a park, disabling the vehicle.
Okay, and after the vehicle came to a stop, did you Did any individuals come out of the vehicle?
Yes, so we saw the car become disabled. Immediately as the car became disabled, came to a stop, the driver's door opened up. One individual fled south.
Okay, and can you describe what this individual was wearing?
So he had like a black puffy coat, looked like it had a hood on it with some sort of fur, and then like light black jeans or gray jeans.
Okay, and after the person jumped out of the driver's seat and was running, did you
didn't say
pursue?
that.
I'm sorry.
You didn't say that. You said one person got out and fled south. I don't know where he got out of.
Oh, where did this individual come out of?
So the white Ford Explorer, he exited the driver's door.
The driver's side?
Correct.
Okay, and what did he do?
He immediately ran like full sprint southbound, going into the backyards.
And did you chase this individual, the driver that came out, did you chase this individual?
No, so my partner, Officer Hopman, in addition to other officers, Officer Peterson, and Padina and Twardy, gave pursuit to him on foot. Myself and Officer Martinez went to the passenger side of the vehicle because the vehicle was occupied twice, and got the passenger out of the vehicle.
Okay, and then did you ever see this individual again, the driver?
Correct, yeah, so the driver was apprehended shortly thereafter.
What do you mean by shortly after?
I mean, I'd say probably within a minute or two.
And this individual how do you know he was apprehended?
So he was handcuffed. I saw him getting walked back to a scout car.
Who was he handcuffed by?
Officer Twardy and Padina, I believe, placed handcuffs on him.
Object to foundation unless he saw them do it.
Right, sorry, I was getting to that. When you saw this individual coming back, was he with other officers?
Yes, he was.
Who were the officers?
So it was Officer Padina and Twardy.
Okay, what was that individual wearing?
The same thing that the driver was wearing, so a large black coat with fur and the kind of grayish jeans.
And then at that time, did you see that individual?
I did.
And do you see that individual here today?
I do.
Can you point to that individual and describe something they're wearing?
So the gentleman wearing the green shirt.
Your Honor, let the record reflect that the witness has identified the defendant. Thank you, Judge. After Mr. Mathis was he taken into custody?
He was.
Okay, did you do any other investigation?
Yes, so, obviously we're still located next to the white Ford Explorer. I got the VIN off of the vehicle.
Okay. Could you describe the vehicle?
Yeah, so a white 21 Ford Explorer, black rims.
And did you, look at what the VIN number was on that vehicle?
I did.
And you had it in your report?
I did.
Your Honor, I believe for exam purposes, the defense will stipulate to me reading the number into the record.
Correct, Your Honor, for example.
1 F N S K, the number 7 F H 2 M G A 88812. Did you do any other investigation?
Yeah, so I took the VIN number off the white Ford Explorer, conducted a lien search, in which case it showed it as a stolen motor vehicle.
What date did it come back stolen, if you remember?
So it had the OCA listed under the February 3rd date.
Nothing further, Your Honor.
Thank you. Officer Durant, when you saw first saw the vehicle in March, had the vehicle performed any sort of traffic violation before you got behind it?
No, sir.
Now, when you initially went to in February and talked to the individual who had his car taken, obviously you didn't see the car get taken, correct?
Correct.
Okay, so you gathered information afterwards, fair enough?
Correct.
Okay. And the individual whose car was taken didn't indicate that he knew who took it or anything along those lines, is that fair to say?
Correct, he did not know who took it.
Thank you.
No redress, Your Honor.
Thanks.
Thanks, sir.
No other witnesses, Your Honor.
No witnesses.
Argument?
Your Honor, at this time, people will divide over on counts 1 and 2. I believe to a probable cause standard. People have the word.
Right, you do the. That's count 1. Where do I get knowledge from?
For the receiving concealing.
He knew that the vehicle was stolen.
Your Honor, I believe there was. I believe there was a confession in a previous case where the defendant admitted to stealing the vehicle. And he bought it for. That it was $600.
That's what I heard from the statement, that he purchased the car.
He purchased the vehicle, $600.
Because, Your Honor, given the fact that it's a 2021 newer model vehicle, price of paying $600 for a new vehicle is kind of suspect to a reasonable person. And the fact that, you know, he was fleeing, that's conscience of guilt.
Yeah, he is afraid. Did he? Well, okay, I got you. Mr. Konecki?
Your Honor, we would object as to count 1 being bound over, that there's just, they have presented nothing as far as knowledge. And we object to that argument with regard to count 2.
All right, court having heard the testimony, arguments, finds that heard from Officer Durant of the Detroit Police Department that on February 3rd, 2023, at approximately 4 o'clock, he was dispatched for a UDAA report. Took the report from Mr. Harris regarding the white Explorer, VIN number ending in 88812. The car was taken and gave no one permission to take the vehicle. We heard on March 15th, 2023, he was on patrol. He was in a fully marked vehicle in the area of St. Mary and 6 Mile. They was looking for an Explorer, white, with black wheels. They saw one, he pulled behind the vehicle to investigate. No lights and sirens, the vehicle did not stop, it fled. The pursuit lasted basically 14 minutes going through residential neighborhoods and on the freeway going the wrong way. Until the vehicle came back up off the freeway, it went through a park area and struck a large rocks. Was disabled. A person got out of the driver's seat, fled south, was wearing a large black coat, gray jeans. That the witness then went to the passenger side of the vehicle and got the passenger out. Within a minute, he saw the officers coming back with the vehicle wearing again a large black coat with gray jeans. It was the defendant. And he had been driving the white Explorer, which again, same VIN number ending in 88812. Also, there was testimony taken from Sergeant Kevin Nanis that he did the interrogation of the defendant, and part of the interrogation, the defendant admitted to purchasing the same vehicle for approximately $600. This is a brand new Explorer worth thousands, tens of thousands of dollars. And the court can take a position and does take a position that in purchasing it for that amount, the defendant knew that the vehicle was stolen. Court finds felonies enumerated in the complaint and warrant did in fact occur in the city of Detroit. Probable cause exists to charge this defendant to be bound over to the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be May 15th at 9 o'clock.
First step is what the-
No, we
Still got
got
3 more
more
cases.
Your
Which
Honor,
one?
I propose we go to next to case ending in 4701.
Okay. All right, this is case number 2356347. That's the state of Michigan versus Mario Mathis. Mathis is charged in this case, count 1, robbery armed, count 2, weapons, firearm, possession by felon, count 3, weapons, dangerous weapons carrying with unlawful intent, count 4, weapons, felony firearm, count 5, weapons, felony firearm, count 6, weapons, felony firearm. And this is a continuation of the, of this hearing, this exam. Your parents?
Brendan Sawyer for the people, P83033.
Jeff Kaneki, P64800, Ben DS, the train, Mr. Mathis.
Sergeant Mario Mathis, Your Honor.
Right, thank you.
And Your Honor, just before I call my next witness, there is a stipulation as it relates to the FIP count. The stipulation of the parties would be that on March 6, 2023, as of March 6, 2023, Mr. Mathis had been previously convicted of a felony of at least 4 years and had not regained eligibility to possess a firearm. That's sort of the gist of the stipulation as it relates to FIP count.
That's correct for exam purposes.
All right, court will accept that for example.
Thank you. At this time, the people would call Ms. Barbers.
First name, common spelling. I'm sorry, common spelling. B-A-R-B-A-R-A. Smith, S-M-I-T-H.
Ms. Smith, can you cross this way, please?
Right here?
Yeah, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Right, pull that door towards you, you have a seat right there. Okay, pull the mic down, that microphone, it'll bend, pull it down a little bit. Oh, there you go. All right, 1 second. All right, Ms. Smith, you're gonna be asked a series of questions, all right? First by the prosecutor. Then the defense attorney will probably ask you some questions. And I may or may not ask you questions, all right? You have to answer all your questions out loud verbally using words. Just can't shake your head like you're doing now.
Okay.
You have to say yes, no, whatever the answer is.
Okay.
You can't say, because none of that comes across.
Okay.
All right? Also, what I need you to do is listen to the question and answer the question and stop. All right? If it's a yes or no question, just say yes or no. If they need additional information from you, they'll ask another question. All right? We all have a tendency when we're talking about something, especially that has been traumatic to us, we tend to ramble.
Okay.
You know, we'll say this happened and this happened and this happened and this happened, go on like that. Well, if you do that, there's a strong likelihood that I'm gonna miss something.
Okay.
All right. And I don't want to do that. If I miss something, I might not make the right decision. Okay?
Yes.
Know nothing about the case, other than what the defendant is charged with and what his name is.
Okay.
I know your name.
Yes.
Okay. I get all my information from what happens in court. One question, one answer at a time. That way I can understand.
Yes.
Okay? All right. Thank you.
Thank you.
All right, may proceed.
Thank you, Your Honor. And just one very brief, quick thing. First, I am, my officer in charge has entered the court and I'd ask for mutual order sequestration for an exception for Officer Adam Langford.
No objection.
All right. Also be allowed to remain. Thank you.
Good morning, ma'am. Can you state your name for the record?
Good morning. My name is Barbara Smith.
And Ms. Smith, I want to take you back to March 6th, 2023. On that date, did you find yourself at the Vanity Liquor Store off the Schaefer Highway?
Yes.
All right. Is that in the city of Detroit, County Wayne?
Yes.
All right. How'd you get there that day?
I drove.
And do you remember what time you got there?
Between 3 o'clock in the afternoon and 3:15.
And what did you do when you got there?
I got my lottery package out to go play my lottery. Got money out my purse, put it in the package because I'll never take my purse in the store, and went inside the store to play my lottery. And came back out to get in my car.
And when you came back out to get your car, did anything happen?
Yes.
What happened?
As I opened up my door, I have an automatic lock. I hit the lock to open the door, and a car zoomed up beside me. The young man jumped out and approached me and told me, "Don't move."
And ma'am, when you say zoomed up, can you just tell, how close to you did this car come? If you recall.
I was parked behind the curb because there's a parking space that you can park there. So my driver's door was probably just a foot maybe from the curb. And that's where the car came up.
Do you have any estimate on how many feet away that car was?
You mean when
it zoomed up and parked next to your car, I should say.
I don't exactly know where the car came from. So I don't know if it came up the street, out the parking lot, I don't know.
But did that vehicle park next to your car?
Yes.
How close was it parked to your car in feet, if you recall?
Quite close, close enough for not, the doors not to, be touching each other, but close enough so that if my door was open and his door is open, nobody could see what was going on.
And do you remember what kind of car it was that zoomed up on you?
All I can tell you is that it was a white, small, looked like a small SUV, I'm not sure. And I say SUV because of the height that the driver was sitting that was in the car.
And how many people did you see in that car?
Just the one that got out and approached me and the driver.
And the person who got out, they come out of the passenger side, the front passenger side, or what are we talking?
The front passenger side.
And what happened next?
He told me don't move.
And what did you do?
I didn't move.
Why not?
I was afraid. Because when he first got out, he put his hand under my arm and I thought he was just trying to help me in my car because of my disability. And I said, "I'm good." And he said, "Don't move." And he said it about 3 times. And that's when I knew that it was more than just him trying to help me.
And so what happened at that point?
He moved, like I said, and he said, give me your purse.
What did you do then?
I told him I don't have a purse.
And at any point during this encounter, did you see any sort of weapons?
Yes.
When did you first see a weapon?
After the one that approached me kept asking me for my purse. And I kept telling him I don't have a purse. I looked up into the car that he jumped out of, and the driver had a weapon. I never saw the one approach me with a weapon, but I did see a weapon within the car, a rifle.
Was it in the driver's hands, near the driver? What are we talking?
It wasn't so much, it was like his arm was resting on it. But it was like he wanted me to see it.
And were either of these two individuals that you saw there wearing anything distinctive or memorable?
I don't remember them wearing anything but all black and masks.
And when you say masks, I see here you got sort of like a surgical COVID type mask. We're talking that kind of mask, some other kind?
No, the driver had a full head mask on, from head, only thing you could see in the driver was his eyes. And the one that approached me had one of those kind of masks that you pull up. It was black, like I see, everything was all black. And it was one of those kind of masks that maybe a scarf or something that they put on and then they pull up. And then all I could see was the bridge of his nose maybe, and his eyes and his hair.
And did you ultimately hand anything over to these gentlemen?
Yes.
What was it?
I didn't per se just hand it over. I told them, he kept asking me about a purse, and I kept telling him I don't have a purse. I said, I don't take a purse with me to the store. All I have is my driver's license and this pouch that I have my lottery in. And so I reached up over my sun visor and got the pouch with my lottery in it, because I knew I had money in it. I said, this is all I have. And he kept saying, what? And the driver kept saying, she's got a brown pouch in here. Get that brown pouch. And so eventually the one that approached me said, just move, and kind of like pushed me a little bit out the way to get into the car.
And ma'am, did you hand over any sort of brown pouch?
No.
Did you ultimately hand over any cash?
It was in the little lottery package that I had.
Right. And do you recall how much money that was?
It was $100 bill, a $5 bill, and 4 ones.
Did you hand over anything else?
I had my driver's license in my hand, so he just snatched my driver's license out of my hand.
And what happened after they took that with you?
When he took my license, by that time, people had started coming out of the store, and the traffic was getting a little heavy where we were, because we were right at the end of the driveway. And so when he kind of pushed me to the side to say, get out my way, let me look, the driver said, come on, just let's go, let's go. And he turned around and jumped in the car, and the car took off.
How long, if you recall, was this entire interaction from when they zoomed up to when they left?
I want to say about, it seemed much longer, but about maybe 5 or 10 minutes.
And you said this was already at the Vanity Liquor Store?
Yes.
And do you know that to be located at 20516 Schaefer Highway?
That sounds about right.
And did you call the police?
I did after I got home.
No further questions, Your Honor.
Thank you, Judge. Mrs. Smith, when the individual got out and then kind of put their hand on your arm, told you not to move, and at that point, at first you indicated you thought they was just trying to help you into the car or something, correct?
Yes.
Okay. And then he said it a few more times, correct?
Yes.
Okay, and that's when you felt there was something else was going on, correct?
Yes.
And you began to feel concerned?
A little bit more than concerned.
Okay, I guess I'm kind of getting, you would have, I'm assuming you probably got concerned and then as you thought more about it, realized, and you were afraid.
Yes.
You were afraid for your own safety, fair enough?
Yes.
Okay. Now, the car that pulled up next to your car, was it on your driver or passenger side?
Driver.
Okay, so the vehicle, did it pull in or did it back in?
Their car?
Their car, yes.
It pulled up.
Okay, so it's on your driver's side, meaning the passenger side of their vehicle is next to your driver's side, correct?
Yes.
Okay. And then the individual that came out and interacted with you came out of the passenger side, correct?
Yes.
Okay, so then, can you give us an idea of about how far apart the vehicles were? I mean, I can kind of, if Mr. Sawyer is your car and I'm the other one, kind of give me an idea of where to stop.
Come back up more. A little more. In one? Yeah. about like-
Somewhere, okay. 2 to 3 feet,
Yeah.
roughly?
Yes.
Okay, okay. And then when the individual got on the passenger side, did they close the door to their car?
No.
Okay, so the door was open, correct?
Yes.
Okay, was the door to your car, the truck? Okay. The passenger door on the white car was open, correct?
Yes.
Okay. Was the driver's door on your car open?
Yes.
Okay, so they're both open and kind of, are they touching each other?
No.
Okay, they're close to each other though?
Yes.
Okay. And you said the individual came out and said, don't move, correct?
Yes.
Okay, and then they were then after a few times of telling you don't move, they tried to get your lottery tickets in your little pouch, correct? Or is that what they asked for, I guess I should?
They didn't ask for the lottery tickets or
Okay.
anything, but I reached up and said, this is all I have.
Okay. So did they ask for something specific or did they make a general demand?
They asked for my purse.
Okay, and then you went into your car and I believe you said it was in the visor area?
The pouch.
The pouch.
The lottery ticket holder was over my driver's visor.
Okay, and that's what you gave to them, correct?
Well, I didn't actually give it to them. I put it in the door of my car, right on the side. And I said, this is all I have. And
Okay, so you took it out of the visor, kind of put it down to the side, told this is all I have, and then that individual took it, correct?
I didn't see him take it. All I can say is that I didn't have it anymore.
It was gone.
Mhm.
Okay, is that a yes? Sorry, sounded the answer was a.
I'm sorry.
The pouch with your money and your lottery tickets after you set it on by the door of your car was gone.
Yes.
Okay. When you looked into the car, you said you indicated you saw what you believed to be a weapon, correct?
Yes.
Okay. Was the interior of the car illuminated?
No, not that I can.
Okay. And did the windows, if you remember, on the vehicle have tinting?
I don't know.
No, okay. And you looked into the car and you saw what you believed to be a weapon, correct?
Yes.
Okay, but as you indicated, it was sitting on, where was it sitting?
Right next to the driver's right arm.
Okay, was it sitting on like a console or?
I'm not sure.
Okay. How much of what you believe to be a weapon could you see? What did you see of it?
I saw the entire
Okay,
weapon.
so you could see the entire weapon where it was sitting?
Yes.
Okay, but that weapon was never pointed at you?
No.
Okay. No one said to you, give me your stuff or we're gonna shoot you?
No.
Okay. Nothing.
Very briefly, Your Honor. Ms. Smith, you testified that one of the gentlemen who exited the vehicle sort of came up and grabbed your arm.
He didn't grab it. He just kind of gently put his hand under my elbow and said, don't move.
Okay, and I do see that you have a cane here today. Did you have a cane with you back on March 6th there at that location?
I might have had a cane, but I might not have been using it because I don't use it all the time, just when I'm having difficulties with my leg. And a lot of times, when I'm getting in and out of the car, I don't take it with me.
Fair enough. No further questions, Your Honor.
Nothing further, Judge.
All right, thank you, ma'am. Thank you.
Thank you.
No, it doesn't. Remember, it's convenient. And Your Honor, once she's out of the courtroom, I'll have a motion.
Well, you have any further witnesses?
Not for this case.
No witnesses.
Thank you. Now,
Your Honor, at this time, the people would move to bind over on all counts as charged in this particular case. Heard from Ms. Smith as it relates to the robbery that took place on March 6th at 3:12 p.m. there at the Vanity Liquor Store. When you combine that with Mr. Mathis's own statement, we've already heard at least once. When you put those together, you reach the conclusion that Mr. Mathis is in fact the individual who robbed Ms. Smith on that day at the liquor store there. I just want to talk very briefly because there are a couple of differences in his statement and in Ms. Smith's sort of version of what happened that day.
well, that makes it a question of fact, don't it?
Yes, I certainly would. So, her testimony speaks for itself, Your Honor, and so people would move to bind over on all charges and reserve any argument for.
All right, thank you.
Your Honor, would object to the bind over. The argument that I'm presenting specifically goes to counts 2, 3, 4, and 5. Sorry. There's no evidence that this lady woman looked into the car while she was afraid and saw what she believed to be a weapon or a gun. There's no evidence that it was a real weapon, a real gun. But specifically, I'm sorry.
It doesn't have to be. It only has to be what's in her mind, what she thought it was.
That specifically to count 3, I would indicate that the count requires that it was carried, the intent to use carrying with unlawful intent, did with the intent to use the same unlawfully against the person of another, go armed with a firearm with a rifle. This weapon was never used, it was never done anything, it was sitting in the car and she saw it, it was not used against her, so we believe count 3 should be dismissed, and then object without argument to the remainder.
Just very briefly, that by Mr. Mathis's own statement, he was in fact the driver of the vehicle. The driver of the vehicle is the one who decides where it goes, where it stops. I believe the evidence in this case suggests that he stopped right next to Ms. Smith for the purpose of robbing it. He didn't need to point the gun at her. The court saw her today. The court heard her testimony. She was just there to buy some lotto tickets, and by Mr. Mathis's conduct, affected an armed robbery. Thank you, Your Honor.
Court having heard the testimony, arguments, findings as follows. March 6, 2023, that Ms. Barbara Smith went to the store at Schaefer between 3 and 3:15 p.m. It was broad daylight, playing lottery. She came out back to get in the car. As she opened up her door, a car zoomed up to her, right next to her car. A young man jumped out, kind of put his hand under her arm and told her, "Don't move," said several times. They're driving a white small SUV, 2 passengers. And she said, we said that don't move 2 times. She said that she was afraid. He said to give him her purse. She said she didn't have a purse. That all she had was a little pouch, with a lotto and some money in it, a driver's license. She took that from her car and put it in the door of her car. And that she didn't see the person take it, but it was not there any longer. Also, that the driver, who was wearing she could see was wearing a full face mask, had a rifle in the vehicle with him. and that, she could plainly see the rifle and the way that he was looking at her. It was obvious to her that he, and this is her, it was in her mind, the witness mind, not in the defendant's mind. It was in the victim's mind that the driver wanted her to see that rifle. We also have the statement from the interrogation that defendant admits to being there at that location, and that he was the driver. He pulled up. He saw an older woman walking for a car. They pulled up, and boy said her give her stuff. He said he threw the loud in the air, the purse in the car, and that they took off. However, Ms. Smith's version is a little different, and as such is a question of fact for still. The felonies enumerated in the complaint warrant did in fact occur in the city of Detroit, probable cause this charge is defendant will be filed over the Wayne County Circuit Court of Criminal Division for arraignment on the information, which will be on the 15th at 9 o'clock. Okay, which one will we do next?
Let's do the one ending with 101.
All right, this is case number 2356001, People State of Michigan versus Demario Mathis. Mathis is charged in count 1, robbery armed. This is a continuation of this matter. Initial part having been heard earlier this morning. Harris.
Brendan Sawyer for the People, P83033.
I may please the court, Neighborhood Defender Service of Detroit by Jeffrey Kaneki, P64800, on behalf of Mr. Mathis. Sir, say your name.
Yes, sir. Demario Mathis, Your Honor.
Thank you.
Yes, sir.
Your Honor, necessary witness having been notified of today's date. In fact, had multiple conversations, myself and the officer in charge with Mr. Ware. Is not present at this time, despite being subpoenaed to be here at 10:30 and the current time being 12:19 p.m. As a result, the people are unable to proceed on this case.
Move to dismiss, Your Honor.
All right, now it's dismissed. Just need a dismissal form, please.
Yes.
All right, that leaves case number 2356346, People of the State of Michigan versus Demario Mathis. Mr. Mathis is charged with count 1, carrying concealed weapon, count 2, weapons, firearm, possession by a felon, count 3, weapons, felony, firearm. Appearances, please.
Good morning, Your Honor. Brendan Sawyer for the People, P83033.
May it please the court, Neighborhood Defender Service of Detroit by Jeffrey Kaneki, P64800, on behalf of Mr. Mathis. Sir.
Yes, sir. Demario Mathis, Your Honor.
Thank you. You ready to proceed?
Yes, Your Honor. And just very briefly, Your Honor, the people and the defense do have a stipulation as it relates to the previous felony as associated to count 2. The stipulation with parties would be that on or about April 8th, 2023, Mr. Mathis had been previously convicted of a felony punishable by 4 or more years, and the requirements for regaining eligibility had not been met.
Correct for exam purposes, Your Honor.
And at this time, the people would call Officer Brandon Eli.
Eli, Officer Eli.
I don't have anything at all.
You swear our firm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do, sir.
All right, pull the door for you, have a seat, please.
Thank you, Your Honor. Sir, can you please state your name for the record?
Yeah, Brandon Ely.
And Officer Ely, how are you employed?
I'm employed with the City of Detroit Police Department.
Were you employed with the City of Detroit Police Department back on April 8th, 2023?
I was.
What capacity were you working on that day?
I was working in a modified uniform, special ops, unit, the 12th precinct.
And were you working alone with a partner? What are we talking?
I was working alone.
And 12th precinct, that encompasses the City of Detroit and Wayne County?
Correct.
All right. And sir, at some point back on April 8th, 2023, did you find yourself at the area of Water Street and Trojan Street?
I did.
And how did you get to that location?
Originally, it was a shot spotter run that came out a few blocks south of that location. We canvassed the area where we got the 911 call for the shot spotter run. Didn't find any results, so I traveled north down Hubble, approaching Trojan, and I seen a large gathering at the park there.
And you said you were traveling north
Yeah, north from that location.
in a scout car?
Yes.
Was it marked?
It was a semi-marked scout car.
And what'd you do when you saw this gathering?
I made a westbound turn on the Trojan from Hubble, proceeded through down the street, down Trojan, passing the group of people. There was probably about 200 individuals out there.
And you say there are 200 individuals out there. Are we talking all in one front yard? Is this big field? What are we talking?
No, gathered along the street.
And at this time in your scout car, was it just you or were there other people?
It was just me and my scout car.
And what happened next?
I proceeded down Trojan, passing a large amount of the individuals that were gathered out there, getting towards the end of where the gathering was, and observed the offender next to a vehicle.
And you said just now getting towards the end of where the people were. What do you mean by that?
Correct. So the group of people was thinning out as I proceeded down Trojan. So now it was probably a handful of individuals.
And you said that you saw the offender. When you say that, what drew your attention to him?
The offender was originally looking at me as I was driving.
Objection, Your Honor. Can't say he was looking at him. He doesn't know what my client was looking at. He can indicate what direction in the area.
Fair enough. The offender was looking eastbound towards my scout car, in the area of my scout car, as I proceeded westbound towards him. He was standing next to a couple other individuals,
on the north side of the street where a blue SUV was parked. When the individual, I believe, observed my scout car, he quickly turned around, started walking towards the front of the SUV, or I guess going closer to the passenger side of the SUV, bent over at the waist and discarded a firearm underneath the vehicle.
How close were you to this person when you saw them bend down and discard a firearm?
10, 15 yards maybe.
And what made you believe it was a firearm?
I clearly see the firearm. It was a big firearm. It wasn't.
Are we talking rifle, handgun?
Handgun, like a full size handgun.
So what did you do at that point?
At that point, I notified at that time, I notified the scout that was directly behind me, following me down Trojan. I notified them, let them know a quick description of the offender who I observed discard the firearm, and then I immediately tried to make contact by activating my overhead lights, exiting the vehicle, and giving the verbal commands to the offender. I believe I said something along the lines of "Don't do it" or "Stop."
And how far were you from this person when you yelled "Stop" at them?
Less than 5 yards from the street to where a sidewalk would be.
And did you see where this person pulled that firearm out of, if anywhere?
His back was turned towards me, but as he discarded his firearm, he made a motion like this and bent over at the waist and tossed it under the car just like that.
And could you just sort of describe the motion you made?
Yeah, it looked like he was pulling it out of his waistband area.
And after you got out of your car and gave those commands to stop, what happened next?
He began fleeing on foot northbound through the park. We went on a short foot pursuit, almost middle of the park before he stopped, began complying with my commands.
And when you say short, how many minutes are we talking?
I honestly, I can't exactly say. If I had to guess, I'd say probably a minute of running.
And do you see that person that you observed throw a firearm under the vehicle and chased for that short chase across the field in the courtroom here today?
If I may, can I stand up? Yes. I do.
Could you point to him and identify him by an article of clothing?
Yes, he's sitting down over there in the green shirt.
Your Honor, I'd ask that the record reflect the witness's identification of Mr. Mathis. And at that point, Officer Ely, you took him into custody?
Yeah, so at that time, I detained him, placed him in handcuffs. Shortly after that, one of my partners ran over to me. I then again told my partners where the firearm was, where I observed the offender discard the firearm. And one of my partners went back at that time.
Did you observe your partner go back in that direction?
I did observe my partner go back in that direction. I did not observe the recovery of the firearm.
You said it was a blue vehicle?
If I remember correctly, it was a blue Trailblazer SS, older model Trailblazer.
And I know you had said earlier that there were 200 people around when you sort of initially saw this big crowd. At the time you saw Mr. Mathis throw the firearm and sort of this brief chase, were there still 200 people in the area? What are we talking?
They were further east of us, but there was also, I'd say probably about maybe 5, 10 people max in his general area.
No further questions, Your Honor.
Thank you. Officer Ellie?
Ely,
sorry. Officer
No problem.
Ely. When you said you were driving down Trojan and that's where the large group of people were, correct?
Correct.
Okay. And then they were starting to disperse when you said that you saw an individual who looked in your direction and then walked away, correct?
Can you repeat that?
let's go, you're in your vehicle on Trojan, correct?
Correct.
In which direction are you heading?
I'm traveling west.
Okay, so you're traveling westbound in your vehicle. Where is the blue Trailblazer on the street?
If I recall correctly, I believe it was the last vehicle along a line of vehicles. I'm assuming they were vehicles of the people who were gathering there, but I believe it was the last vehicle in that line. So towards the end of where a large crowd of people would have been.
Okay, the vehicle, was it, while you're driving, was it to your left or to your right?
To my right.
Okay. And then, as you indicated, it was from what you remember, the last vehicle in a line of vehicles, parked on the street, correct?
Like I said, I do believe it was the last vehicle or one of the last vehicles in the line.
To the best of your recollection, it was towards the end, okay. And you're approaching that, and then you indicated that the individual that looked in your direction walked over to that SUV, correct?
He was already standing close to the SUV.
Okay.
And then, yes, as
Sorry, I didn't mean to cut you off.
No, go ahead.
Did he walk around the front of the blue Trailblazer?
No, he did not.
Okay, so he walked up to, where did he then bend down?
He bent down on the passenger side of the blue Trailblazer.
Okay, so on the sidewalk side?
Where a sidewalk walk would be, yeah.
The opposite side of the street where you're driving, correct? He's on the other side of the car.
He's on the passenger side of the vehicle.
Okay, and the driver's side is what is on the street where you're driving. Okay, so he's on that side. So as you're approaching, he's on the other side of a line of cars. And then you're saying that you saw him bend down and make a motion to his waist with his back to you, correct?
Correct.
Okay. And you said you saw him bend down from there, make a motion from his waist, and then you indicate toss the gun under the car, correct?
Yes, the other.
Okay, and you saw this while driving, you were still moving in your vehicle, approaching where the.
Yep, I was approaching his vehicle.
Okay, and he's on the other side, through the car. Through the trail.
What do you mean, through the car?
You have to see him through the trail.
No, I'm not.
How do you see him with him on the passenger side?
So there was a large gap in between his vehicle and the line of other vehicles that were closely parked together. I'd say there's probably about a 2 to 3 car gap in between let's say the last vehicle and the vehicle he was near. So there was a large space where I can observe him and the other individuals he was near.
And you said you were 10 to 15 yards away when you observed him, correct?
Correct.
But again, you saw him with his back to you, correct?
Yeah.
Okay, back to you, and then he bends over at the waist, you indicated, correct?
Yeah, after he observed my presence and turned around.
After he looked in your direction,
Yep.
he's on the side of the car, you're driving down the street, correct?
Correct.
He's on the passenger side, and you indicate he bends down, and then you're telling us he threw a gun under the car. You could see him throw the gun under the car.
Yeah, I wasn't next to the vehicle. I think that's
You were still approaching.
I was still approaching. Yep, I'm still far enough back to observe the entire passenger side of the vehicle.
Did your squad car have a camera?
Yes, it does.
Was it functioning? Did it record this?
To the best of my knowledge, it was.
One second. Nothing further, Justin.
Nothing from the people, Your Honor.
Thank
Thank you.
At this time, the people are going to call Officer Lanier Downs.
Offer approved what?
He's the officer who's going to testify about recovering a firearm underneath the passenger side of a blue SS Trailblazer.
Why do I need that? That's a trial issue. It's not necessarily an exam issue.
There's no further witnesses from the people then.
No witnesses, Your Honor.
Right, thank you. Motion.
Yes, Your Honor, at this time, the people have moved to bind over on Alphonse and reserve any argument for rebuttal.
Would object, no argument.
All right, court having heard the testimony, argument followed, passes as follows. Heard from Officer Brandon Ely, who testified on 4/8/23. He was in a modified uniform, working special operations. He was working alone, driving a semi-marked vehicle. He was in the area of Lauder and Trojan. He was in the area initially for a shot spotter run. Saw a large gathering approximately 200 people in the area, drove past the group, got towards the end of the group, and he observed the defendant next to a vehicle. The defendant was looking in his direction, looking directly at the stop car. He then started to walk towards the front of the vehicle, bent over, and appeared to discard a handgun away from his waistband. He then got behind him, activated his lights, then it ran, gave chase, told him to stop, told the officers that were behind him basically what was going on, and where he saw the weapon being dropped. He saw them go in that location to get it. This is a probable cause here. That's all I gotta have. And in this case, based on the officer's testimony, court finds that the felonies enumerated in the complaint warrant did in fact correct to Detroit. Probable cause of this charge of defendant is found over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be May 15th at 9 o'clock a.m.
Thank you, Your Honor. Your Honor, we did want to address the issue of bond. I believe we're trying to figure out, one of the cases was a remand bond. I don't know if it was the one that was dismissed or if it's one that's active. I'm just trying to figure out so that we can address the bond now.
Okay, hold on a second.
The last three is 347, the one he had to remand.
347, that's the one that was dismissed, right?
No.
Nope. Which one is that?
That's the one we heard from.
That's the,
Yep.
Yes.
okay.
That's the case he's remanding on?
Yeah.
Okay. Well, Your Honor, we're asking the court to consider a bond on that matter. Remand would not be appropriate. It's not a murder case. It's not a CSC1, extenuating circumstances. And I believe, I thought that was the original armed robbery that came through. Maybe I'm wrong. But Your Honor, with that one coming through, the remand I would only assume was put in place because it appeared that the defendant would have picked up an armed robbery case on bond with an armed robbery case, but that wasn't the case. They had occurred before. It was a strings. We're just asking the court to set a reasonable bond amount for that case for Mr. Mathis. I believe the other cases, he has bonds posted on. Because he was originally on bond, and then there was the two new cases came through. One of them was the remand, but the remand, I believe, is inappropriate. I think it was just the thought that he had armed robbery, picked up another one while on bond, but they had occurred previously is the allegation. So we're asking the court to set a reasonable bond, 50,000 cash surety, 10% with the GPS tether, something along those lines.
If the court was inclined to change the bond, I'd argue that a very substantial cash bond would be required in this case. Obviously, the court can see on the armed robbery case that was bound over, Mr. Mathis is charged as a habitual offender, fourth offense notice. I do think there's something interesting though when you look at what those prior convictions are, 2018s, 2019s, they're all theft offenses. But importantly, they're not theft offenses involving firearms. From the people's position, these newer cases, they represent an escalation on Mr. Mathis's part. They're theft offenses, but now they're theft offenses with firearms. Further, Mr. Mathis is on probation over at Third Circuit Court to Judge Green's docket for felony firearm and felon in possession. He's on height of probation. Obviously, that's the only way not to be exposed to 2 years MDOC. So at a minimum, a very substantial cash bond. I do think this is the kind of case that there is a need for a DSU report as well. Mr. Mathis has some pending cases in Oakland counties for UDAs. So I do not believe any sort of $50,000 10% bond would be appropriate in this case.
Your Honor, I would indicate that as prosecutors indicate, we have one case that involves theft in a firearm. Not multiple. There's one case where there's allegations of both theft and a firearm. You have separately an allegation of possession of a stolen motor vehicle, fleeing and looting, and then separately the possession of a firearm, and then one matter that has those two elements together. I still indicate to the court that Mr. Mathis is entitled to a reasonable bond on that. It is not something that should be reading.
All right, I would agree that the one armed robbery case would not dictate a necessity for remand. However, also, there seems to be a different pattern of, I mean, he was just on the go. Committing one offense after the other. You know, and as such, I would agree with the prosecutor that a substantial bond would be needed in this case for the safety of the community. I mean, we have. I don't know about the one victim, or alleged victim who didn't show up even after, you know, working for bond. Normally in those cases, you know, I'm a prosecutor that he didn't have a witness and moved to dismiss. He had asked for an adjournment and wanted him arrested, I would give it to him. You know, after a person gets a bond and still doesn't show up. But, you know, your client for the safety of the community needs to be, it needs to be a high cash bond. At this point, I'm gonna set the bond at 500,000 cash. With the GPS tether on our house arrest, if he's able to make that.
Would Your Honor refer the matter to pretrial services? So
We'll give you a referral to pretrial services also.
Thank you, Judge.
You got that, Kitty?
Yes.
Oh.
You're on that approach on another, sort of unrelated. This is an order terminating Mr. Tanner.
There's
They don't show us.
No.
Everyone don't dismiss it. I'll adjourn it and issue a warrant.
8511.
Oh, yeah.
I'm trying to see
I
if
can act on my orders.
Yeah, that's true. Extremely, I would say.
Thank you.
I'm trying to see if I had a, look at our docket, and I can tell you where.
All right, we got two more cases.
He has a prisoner and he has one on the street. Supposed to be at 11:30 and 1:45. One.
Nope.
All right, so we changed his bond. What you need?
He's showing a case in front of Judge Evans across the street, and then one before Judge Bryant here. Bond hearing and a restitution hearing. His docket also doesn't reflect anything.
Yeah, so that's why he's not doing that.
I mean, if you're just gonna adjourn or something, I'm happy to stand in, but.
Yeah.
If the court, I mean, but I texted him, and I didn't get a response either.
One is in jail.
Is it a dismissal? Absolutely, yes. No, that's fine. Yeah, don't worry about it.
Is one of the.
Yeah, the one case was dismissal.
Oh, Glenn, okay.
Where is the defendant?
Oh,
Is he on bond?
actually, I don't.
Oh, that's a problem too.
Is Glenn here? More?
No, Glenn did not show.
Oh.
The other, defendant is a prisoner. His other client is a prisoner.
So Glenn went from a dismissal.
To a case. Wish you could say that's the first time I've had that happen.
Yeah.
You tried it.
Yeah, Mr. Jesus.
Oh, she's trying to give Mr. Jones a call.
He's right, what?
I had it. It was in.
Yeah, we can.
Can you give me some water? I want my cup is.
This.
All right, this is case number 23-56570. People of the state of Michigan versus Clarence Glenn. Glenn is charged with 1 count of assault with a dangerous weapon, felonious assault. Matter was scheduled for preliminary exam at 11:30. Now, 12:46. Glenn has failed to appear. Case shall enter. Any bond previously submitted shall be forfeited. New bond set 30,000 cash.
You said 40? 30.
Okay. Right.
On the record.
And then all the other ones.
Is he calling Mr. Knowles?
Yeah.
So once the case is.
So we can all start.
He's already up. Huh? He was asking.
Can we get Mr. Hall up? He's already
He's
up.
up.
Okay, he's already up here. Do you want me to go talk with him and let him know you're on Zoom? Hello? Do you want me to talk with him and then you'll jump on the Zoom and kind of figure, okay. All right, and I'll let you know what he says. All right, bye.
Judge, you changed his bond to 500,000 cash?
Yes. I didn't do that. Well, that was just the one case that was, sorry.
Do you need me? Oh, I thought you were submit 14. Oh, no, it's over here. That Corey guy, what's going on with that? That was within this. Where?
Oh,
that was me. That was a witness. Oh, that was a witness. For Baptist. The case that was. Oh, okay, so he was.
No, I
Something. It just hit you like all at once. He was okay and cried. Right. No, what happened?
You know, it started getting colder too. That's
Don't be rubbing my hot flash.
Straight a little bit. It happened to some men.
That's the D room.
That's it, period. Be very quick, yeah. Yeah, we still got Malik on. Well, that's right. All right. You're rushing. You're rushing. No, I was wondering what you, yes, no, you say it right. Deputy Mark, Deputy Mark, I got it. The person picked my finger, I said, we got the ball. Oh, I would say that. We're gonna wait one of the, step one out, sir, please. Oh, right there.
Oh, you just sign it?
Yeah, I guess it's signing. It's, oh, prosecutor, who's gonna do this? It's me.
Cardi.
Thanks, Judge.
This is case number 23-56562. People in the state of Michigan versus Malik Hall. It's charged count 1, police officer fleeing 3rd-degree vehicle code.
Good morning, Judge. Alex Winger on behalf of the people, P number P86590.
And may it please the court, Neighborhood Defender Service of Detroit by Jeffrey Pinocchio, P64800, standing in for the attorney of record, William Noakes, with Mr. Hall. Is that correct, sir? Yes, right. Pleasure. Your Honor, after discussing this matter with Mr. Hall this morning and having relayed to him that the people's intent, if Mr. Hall held the exam, was to try to add an additional count. Discussing that with Mr. Hall, he's indicated that he wishes to waive his preliminary examination, understanding he'll be bound over to the circuit court as he's currently charged. Is that correct, sir?
Yes, sir.
Right. So I understand that you have a statutory right to preliminary exam, or the state must show by probable cause a crime was committed, and probable cause you had something to do with committing that crime. You understand that, sir?
Yes, Your Honor.
Anybody promise you anything or threaten you in any way, you should waive your right to preliminary exam.
Oh, Your Honor. I'm sorry.
You waive your right freely and voluntarily after having the opportunity to talk to your attorney about it.
Yes, Your Honor.
And you sign your name to the waiver of examination form?
Yes, Your Honor.
All right, so I find you freely and voluntarily waive your right to preliminary exam as bound over the Wayne County Circuit Court Criminal Division for arraignment on the information. Why are you locked up?
I believe there's a hold on the, he's got a probation case across the street. It's the hold up.
All right, it's gonna be, May 15th.
Thank you, Your Honor.
Thank you, Judge.
You too.
I don't know, Mr. Notes, he just.
I don't know, he
showed up.
Right, the way I talked to him, it sounded like he did not know or realize that these were out there today. I don't know if he had the wrong date or something. Which I'm now concerned that if he had the wrong date, he may have given Mr. Glenn the wrong date, could be why he wasn't here.
Oh.
So I don't know, I mean, I don't know, I'll let Mr. Noakes figure that out with Mr. Glenn, and if that's the issue,